everyone, and welcome to Crime in Court. My name is Heather, and this is episode 28. I can't believe we're on 28. Part 1 of Canton Cover-Up. We are going to be talking about the buffer zone today, and it is in the hands right now of the Supreme Court to review a reply to the first petitioner's brief that they submitted to the Supreme Court. So we are going to get into it in just 1 second, but I wanted to give you an update on Aiden Carney, because Turtleboy, because he is also part of this story, and his part of the story is about freedom of speech being suppressed as well. And part of that was done with the help of an ex-side chick of his and some frenemies that she made that really hate Aiden, and basically she was set up to put him away for these charges that put him away for the 60 days back in December, when he was arrested for that, for apparently revoking his bail or whatever, because he violated his restraining order or whatever. So yeah, so he on Friday had a hearing. He basically, this restraining order that this woman has against him is like a weapon, where she can just go into the courtroom when he's there and say adios, and can try to get him rearrested. So he tried to go get this restraining order amended or lifted completely, and this is the reaction after he got the results or the response from his judge on this case. So here's Turtleboy walking out of court Friday this week, or this past week, and this is Tom CPU's channel. He gets the exclusive interview first out of the hearing. Here we go.
New order, brand new. Nice. So let's be clear, that was a...
They just want to stand here.
Oh, yeah. That was a complete and total victory. The only thing I wanted to do was go to the Karen Reed hearings. And I can go to all and feel safe and know that I would not be, set up to go back to jail for a violation of my bail. And now we can. That courthouse, 50 yards from that courthouse, is a safe space for Turtleboy. I will be here all the time during the Karen Reed hearing. And you know what? You can't even go inside anyway to the courthouse. So we're going to be hanging out outside. And as long as I'm within a 50-yard perimeter, I will be completely safe. And it's very clear, if you guys listen to the judge's language, that he believed me. And to me, that means something. Like, I don't like being falsely accused of anything. And it was a sense of satisfaction the way the judge knew that she was lying. He knows she's lying. He knows that she lied to have me put in jail. He's disgusted by that. He wanted to do it. There's a reason he took 20 minutes. He was looking for something, some sort of case law that enables him to vacate a restraining order. He said, I looked, I couldn't find it. But he made sure to add, based on the testimony I heard in this courtroom today, in other words, based on the lies that I heard from her, and based on the truth that I heard from him, I am amending this order so this man can go and continue his award-winning journalism on the Karen Reed case like no one else is doing. So this is a complete and total victory. We initially, by the way, contemplated just trying to get it amended. That's all we really wanted, but we went big. We went for the fences. We get a double instead. That's fine. We still got on base. It's still a victory. It's not an out. We win, and we're going to keep winning from this point forward.
So he goes on to answer some questions on the court steps, but I'll let you go to Tom CPU's YouTube page and watch that yourself. So interesting stuff, right? So now we know that because they recently just received all of Lindsay's phone records, that's a girl's name or woman's name, they just received all of her phone records handed over by Brian Tully, except for her communications with Brian Tully, but all her communications with Ken Mello and Aiden's enemies, and they're only enemies because they hate him so much and they want to take him down. Like, it's really, he has nothing against these people other than, he wants nothing to do with them, but whatever. I don't know anything about their history. I just know that there are people that hate him. And there are a lot of people, Karen Reed, guilters, that hate Turtleboy. It's a coincidence. I don't know. Anyways, so let's take a quick look at, so let's get rid of that. So what we're here for is, this is, so this is the Norfolk petitioners here for the, to eliminate this buffer zone or to contest it, that Judge Cannoni put in place. There's a 200-yard perimeter buffer zone. People are not allowed to protest. You can't wear free Karen Reed stuff inside this buffer zone. And now they're not even letting people like press or non-press in the buffer zone. You're just not even allowed in the buffer zone they're trying to do, unless you're just, like moving, walking. You're not allowed to stand. So this is the individuals that, oh, I'm on the wrong screen, sorry. These are the individuals, and let me zoom in and, oops. I just forgot to switch over after the video. So here is the petition from these particular individuals, Tracy Ann Spacuzza, Lorena Jenkinson, Dana Stewart Leonard, Paul Cristofaro, Freedom to Protest Coalition, Nicholas Rocco, and Jen Silveria. These individuals all pooled their money, their resources, and whatnot together to come forth to petition to get this buffer zone removed because it is unconstitutional. You're not supposed to intervene with someone's right to congregate, to meet, to protest, to stand out. And that's what this is infringing upon. And she's calling jurisdiction over property that isn't even hers. So we're going to go over this, and we're going to, this is the original brief. And then we're going to go over the amicus curiae brief, or memorandum, which is from the ACLU, the American Civil Liberties Union. And we've already read that on my channel, but I wanted to put everything together. So in these two parts, you're going to have the majority of everything you need to know about the buffer zone. Because in the next part, we're going to go over the response from the Commonwealth, their reply, which this is the Commonwealth's brief, to the expedited review. So the Supreme Court wants an expedited review of this particular case. So that is why this is extremely important right now. We'll also go through in part 2 the petitioner's reply brief. So this is after the Supreme Court said, we want more information, this is the more information. So we'll go through that in part 2. So for now, just to make my computer a little faster, let's close those and go right into it. All right, so this is the petitioner's brief. Mark Randazza prepared it. And I got the ACLU too. Or no, the Center for American Liberty. That's something different. Center for American Liberty. All right, so we're going to skip right to page 8. We're going to get to the statement of issues. So what is at issue here? Number 1, does a trial court judge have the power to create a prior restraint zone or a buffer zone outside the courthouse on public and private property? Because that's what she did. Number 2, if a trial court has that power, should it not exercise that power only after making findings of fact based on admissible evidence and applying those findings of fact to the analysis? Meaning, she didn't do that. Number 3, if any government, she meaning Judge Cannoni, who is the one that put the order in place. When I say she, I am referring to Judge Cannoni, Beverly Cannoni. Number 3, if any government authority creates a prior restraint zone, should it do so with specificity and in a narrowly tailored way? Number 4, what form should any restriction take in order to properly respect the First Amendment? So, were there other things that could have been done that wouldn't restrict the First Amendment so much? Maybe look into those instead of, nope, just buffer zone. And it's really because they don't want the bad press. They don't want the press that is coming to town to be seeing all these people protesting and standing out for something they believe. And number 5, should a court permit intervention from non-parties in a criminal case before making a decision that impacts their First Amendment rights? Meaning, Judge Cannoni denied them the opportunity to speak about how their First Amendment rights would be impacted. So the statement, and she did, she could have listened. Mark Randazza came to court that day after they filed their brief with the court and tried to appeal that, and she flat out refused to listen to him. So, and that, I mean, that's her choice, but that's what she did. So the statement of the case: in the Norfolk County Superior Court, the Norfolk County District Attorney for the Commonwealth filed a motion seeking a 500-foot zone surrounding the Norfolk County Superior Court, barring any and all demonstrations. 4 of the appellants sought relief to intervene for the purpose of asserting their rights, which would have been adversely impacted by the court's granting of the government's request, including their right to protest. The Superior Court denied the motion to intervene, ruling that intervention is not permitted in criminal cases. The Superior Court granted the government's request for an exclusionary zone. The order did not address the source of the Superior Court's power to create the zone, nor did it address any narrow tailoring or making a finding of fact. The only tailoring that it engaged in was to trim the zone from the 500-foot request to 200 feet. The 4 individual petitioners, those 4 appellants, were Tracy, Lorena, Dana, and Paul. And if you watch Resistance is Silence, you've seen Tracy, Dana, and Paul. I don't believe I've ever seen Lorena on anything that I know of. I could be wrong, but maybe she guest starred. But they have their own show, their own YouTube channel where they do live shows and they give updates on where their standouts are going to be and things like that. And that was more so throughout when there were hearings and things. But now, I mean, it's trial and they're going to be there every day. All right, so the Freedom to Protest Coalition, an unincorporated group of citizens who seek to protect the First Amendment and who are adversely impacted by the Superior Court's order creating the zone, organized and filed its own petition under GL 211-3 directly to the single justice of the Supreme Court. All right, so both sets of petitioners in their petitions and in emergency motions to stay the lower court order argued that the Superior Court lacked the power to create the zone in the first place. If it had the power to do so, it had not made evidence-based findings of fact to support it. The petitioners also argued that the Superior Court had not engaged in sufficient narrow tailoring. On April 12, 2024, the single justice denied both sets of petitions and motions, addressing only the issue of whether the zone was proper and determining it was a reasonable, content-neutral time, place, and manner restriction of speech. I mean, it depends on how you look at it. The single justice's ruling did not address the scope of the buffer zone, which forbids all demonstrations. That's the key. That's the illegal part. That's the unconstitutional part. Regardless of whether they are related to the asserted reasons for establishing the zone, and has no temporal tailoring. The single justice did not address the issue. So the single justice is the one who looked at this case, or chose not to look at it necessarily in its entirety, but they ruled on it nonetheless. The single justice did not address the issue of the Superior Court's power to legislate a zone at all, nor did it address the fact-finding process, simply accepting as undisputed facts that the Superior Court declared without anything in the record to support them. So let's go down here. In footnote 6, in the single justice's order, he erroneously noted that the petitioners had not challenged the lower court's findings of fact. Given the expedited nature of the proceeding, errors were to be expected. However, the appellants specifically dispute this finding by the single justice. All right. The single justice also did not address the issue of a right to intervene on the basis that expedited relief on that issue was not necessary. And on that footnote, appellants do not criticize that determination. However, the fact that there is no guidance from the SJC to its subordinate courts on intervention is an issue that is inevitable to be repeated, yet will evade review. Accordingly, the full SJC should take the opportunity to give trial courts clear instructions on this issue. Moving on. On April 12th, 2024, all of those petitioners, the appellants here, combined their efforts and appealed to the full SJC. On April 19th, 2024, the SJC ordered the petitioners file their brief by April 23rd, and the respondents file their brief by the 24th. Statement of fact. Commonwealth versus Reed is a high-profile murder trial being held in Dedham. Thousands of people are following this case, and the weight of public opinion, at least among those who are vocal about the case, is highly critical of the government and in support of Karen Reed. Okay. There's just some source there. So small groups of protesters have fanned out across the Commonwealth protesting in Karen Reed's favor. As jurors are impaneled at Karen Reed trial, her supporters gather at a distance. And there's footnote 5. Okay, so these are all just links and sources that they're referring to, so I won't keep looking. All right, handfuls of pro-Karen Reed protesters have gathered in Dedham over the past few weeks, peacefully gathering on the sidewalks and the steps of the Norfolk County Registry of Deeds across the street from the courthouse. Judge refuses to step down in Karen Reed's trial. Yes, if you aren't aware, they did ask for Judge Cannoni to recuse herself. I did an episode reading through that, through the document. She obviously did not. So this person says Karen Reed supporters protest outside Dedham Courthouse. I don't know how to say that. Munash Kwangwuri? Sure. They're saying that Karen Reed supporters protest outside Dedham Courthouse. Karen Reed's trial, protesters' pink show of support and jury selection. So that was one of the things, because the judge banned free Karen Reed stuff, everyone started wearing pink on Karen's suggestion. All right, so petitioners are not aware of a single pro-government protester anywhere at this time. There's no one out there protesting Karen Reed's side. There's hecklers of Karen Reed, but there's no one really standing out there and going, the Commonwealth got it right. No, there's none of those. All right, so the Norfolk County District Attorney's Office has been heavily criticized for its conduct in the case. Abby Patkin, Norfolk DA, says he's unconcerned by federal interest in the Karen Reed case. Whether that criticism is deserved or not is irrelevant to the First Amendment issues. However, the district attorney responded aggressively to that criticism, and the DA took the position that if a protester can be seen by a witness, then they are violating the law. And this goes back to the whole witness intimidation statute that they are weaponizing against the people of the town. They're weaponizing it against Aiden, and if they could get Karen on it, I'm sure they would. They've tried. All right, so the most vocal journalist, Aiden Carney, has been charged with alleged witness intimidation. See, Abby Patkin, Turtleboy blogger, encouraged minions to intimidate witnesses in Karen Reed case, prosecutor says. Yeah, they called everybody minions, and for that purpose, people started wearing minion stuff or having minion signs, because it's an insult to say anyone who supports Karen Reed is just a mindless minion that follows Turtleboy blindly. Well, what about all the people that blindly follow the mass media, or the mass media, who are saying Karen Reed is guilty because they got their information from the Commonwealth? So what's the difference? The people on the Karen Reed side have read through all the documents, and they know the court case very well, not just some garbage that's fed to them through some mouthpiece on TV. But anyways, let's continue on. And in this particular case, the NCDA sought a ban on all protests within 500 feet of the courthouse in Dedham. So the Norfolk County District Attorney sought a ban. You can fill that in there. All right, so the Commonwealth claimed that it needed this zone where all expressive activity would be suppressed because it said it could not get a fair trial without it. Yeah. How about all the trials we've ever had throughout history that have had people coming and making a huge total spectacle out of it? Making a circus out of it. O.J. Simpson, other big, high-profile cases. This is not the first time this has ever happened in the United States. And people are allowed to protest on the courthouse steps. There's nothing more American than that. And the fact that they think that they can control that, it infuriates me. All right, so in an apparent, did I read that? The Commonwealth claimed that it needed the zone where all expressive activity would be suppressed because it said it could not get a fair trial without it. In an apparent attempt to make the prior restraint zone seem content and viewpoint neutral, they sought a ban on all demonstrations, not just anti-government demonstrations. However, there have been no pro-government protesters. Accordingly, the ban sought was effectively a ban on one viewpoint. And that is beautifully put, because they put out a blanket. You can't wear anything, any support for any side, period. You can't protest, period. You can't whatever in this zone. But there is no one on the other side who is doing the things that the Karen Read supporters are doing for her. No one's doing that for the Commonwealth. So you've basically just wiped out everyone on one side. And that's not fair. Alright, so accordingly, the ban sought was effectively a ban on one viewpoint. Nevertheless, the facial ban they sought, and the one ultimately granted, was indeed content-based, despite the mischaracterization of it as content neutral. Commercial speech is permitted in the zone. What's commercial speech? News media vans emblazoned with familiar logos like the NBC Peacock are ubiquitous within the zone, and that is true. So all these news vans and everything are in this zone. So what makes that speech okay? Because it is a logo to your company on your van. That is speech, and that's showing, I don't know. I mean, not that I care that an NBC versus an ABC van are there, but if you're gonna block speech, you better do it all across the board. Alright, but political speech is not. So, yeah, that's the difference. You've got commercial speech there, but political speech is not allowed. That distinction turns the hierarchy of expression upside down. To justify the effort to end the anti-government protests, the DA claimed, without any attribution to established facts nor even admissible evidence, that there has been witness intimidation in this case. The government indeed has accused 9 people, Canton 9, of witness intimidation for standing on the busiest intersection in Canton holding signs. I mean, it doesn't get crazier than this, guys, does it? Alright, so docket number whatever. Alright, so in these cases, the government took the position that since a potential witness hypothetically could have seen those signs, that equaled witness intimidation. Like, you don't even know. We don't even know that Chris Albert saw those signs because they were standing kitty corner to D&E Pizza, which is where Chris Albert, one of the witnesses from that night, when John O'Keefe was found unalive on another fellow Boston police officer's lawn, he looked up to Brian. Chris is the brother of the homeowner, Brian Albert, if you're not aware, and it's Chris's establishment, the D&E Pizza. And so if these people were standing in a public street and it just happened to be somewhat close to the visual of D&E Pizza's window, how do we even know that Chris Albert saw us? And how do we know that he can see us from that location in order for us to know not to be there in the first place, which is, we wouldn't know because it's a bad statute. You know what I'm saying? Like, there's no logic here on the Commonwealth side. Why would you think standing outside someone's establishment with a sign protesting the government would have any negative effects on yourself? Anyways, so in those cases, the government took the position that since a potential witness hypothetically could have seen those signs, that equaled witness intimidation. However, not one person has been found to have intended to intimidate. Everyone is peacefully protesting with signs that may say, "House long to die in cold," or "Colin Albert was in the house," or "Free Karen Read," "Free Turtleboy." Those are the kinds of signs you might see. So I don't know how that's intimidation, but they say it is. In short, these are anti-government protests and anti-government reporting. The government arrested an anti-government journalist. The government charged anti-government protesters with an unconstitutionally broad interpretation of the witness intimidation statutes. In this footnote, it must be noted that some of those protesters sought relief from the District of Massachusetts, and the District of Massachusetts held otherwise. However, the decision is currently on appeal to the First Circuit. It is likely that the SJC will receive a referral from the court to render its opinion on how to interpret GL 268, 13A, and 13B. Those are the ones that they're using that's the statute that they're using to intimidate or to make intimidating witnesses a crime when they're just weaponizing it. And presumably this court will not agree that the mens rea requirement in 13A and 13B is no longer required, and that the mere act that a sign can be seen by a potential witness does not equal intimidation. So take that, Commonwealth. All right, so now not content to chill speech with these tactics, the district attorney asked to create a zone where all non-commercial speech would be banned, and the Superior Court indulged that request without the authority to do so. Even if it had the authority, it wielded it improperly. The four protesters who initially sought to intervene specifically disclaimed any desire to intimidate any witnesses or jurors. Tracy Ann Spocuzza wishes to demonstrate that Nicola Sacco and Bartolomeo Vanzetti, Sacco and Vanzetti, were wrongfully convicted in datum. So that's all she wants to demonstrate. It is her intent to hold a sign outside well, you had to say what your intent was. In this, I remember they said that they had to say their intent. I don't know. It was her intent to hold a sign outside commemorating the injustice perpetrated upon them, with a statement that the Commonwealth of Massachusetts is not to be trusted. She wishes to do so outside the courthouse because she is aware that the press will be there and the public will pass by, and therefore that is where her demonstration will be most meaningful, and that is why people use the courthouse steps. She has not settled on the exact content of her signs that she will hold each day, but she intends to commemorate the injustice done to Sacco and Vanzetti and to draw parallels that she sees in this prosecution. She wishes to communicate that everyone deserves a fair trial. Sacco and Vanzetti did not get one, but Karen Reed should. Lorena Jenkinson and Dana Stewart Leonard wish for the public to focus on how this trial is conducted, ensuring that the public is focused on it and they pay attention to it, even if the public cannot attend the trials themselves. They are aware that the press will be outside the courthouse, and they want the press to see what they have to say on their signs. That's the whole point. I mean, you demonstrate for a reason. You demonstrate to draw attention to the cause. So, I mean, that's the whole point. And by you pulling people away and splitting them up because you just don't want to see the bad things they're saying about you because you have such a fragile ego, then that's a problem. All right. Jenkinson also wishes to criticize the police and the prosecutors in this case by holding up signs in support of the Canton Nine, who were previously charged with witness intimidation for demonstrating about the Karen Reed case. In other words, a protester wishes to protest the fact that the government has intimidated other protesters. They have that right to do so. Paul Cristoforo wishes to demonstrate to call attention to his belief that the Commonwealth, the district attorney, and the police are not to be trusted. He intends to hold up a sign that says "Free Turtleboy" in support of a journalist, Aidan Carney, who has been prosecuted for engaging in journalism pertaining to this case. He also intends to hold up signs that say "Free Karen Reed." Additionally, hundreds of other citizens wished to protest as well. Immediately after the 4 individuals were denied intervention, they formed the Freedom to Protest Coalition. That group exists solely to exercise their rights in relation to this case, yet it consists of a diverse group of more than 500 citizens who wish to protest on a variety of subjects. A current roster of the membership and the topics they wish to protest is available in Exhibit 1 to this brief. Many, I don't know if we have it. I don't think so. All right, so many certainly wish to protest about this very case and about their belief about Karen Reed's innocence. However, others simply believe that with news cameras surrounding the courthouse, it will be a good opportunity to seek attention for other causes, much like those who stand outside Good Morning America live broadcasts holding up signs for their causes, or others come to sporting events and holding up signs containing Bible passages. The views sought to be expressed are as diverse as Black Lives Matter, the Free Mom Hugs organization, Disabled Americans Against Child, I'm not going to say those words, and for women's rights and equality in favor of LGBTQ rights, or to make a religious statement. There were a bunch of those are all the people that have different things to say. That was what they have to say, what they want to stand up for. All right, so however, one of the largest subgroups is the group of people who simply want to protest in favor of the First Amendment and against what has happened here. In an act of the First Amendment, the order deprives them of their First Amendment rights, and they want to protest this deprivation. Rejecting input from interveners, the Supreme Court established a 200-foot zone where, inter alia, no individual may demonstrate in any manner, including carrying signs or placards, within 200 feet of the courthouse complex during trial of this case unless otherwise ordered by this court. The addition of "unless ordered by this court" is difficult to understand, as the Superior Court refused to permit third parties to intervene. Why would the Superior Court issue a subsequent order? The order applies to this zone morning, noon, and night. The order applies to all demonstrations, but does not apply to commercial speech. And as noted above, commercial speech has been permitted without any objection at all. Only political speech has been banned. Right. The Superior Court failed to undertake the slightest analysis with respect to which evidence-based facts it relied on, nor did it engage in any narrow tailoring analysis. It simply drew a broad shape and said, in essence, there can be no political speech in this zone. And while the zone is facially viewpoint neutral, it was created solely to exclude anti-government speech. After all, if there is only anti-government speech and the government responds by seeking to ban all speech, it is clearly doing it to target anti-government speech. I mean, how can you argue with that logic? It just makes sense. It is as if there were a synagogue that annoyed the government because of the religion being practiced inside, and the government simply banned all houses of worship within a geographical zone which only contained that synagogue. A pernicious element to this order is that it is based on a fictitious narrative that even the government did not propose. The order reads as if Karen Reed asked for it. RA 61, stating the buffer zone is justified because the defendant here is entitled to a fair trial with an impartial jury, free from outside influence, focused solely on the evidence presented in the courtroom during the trial and applicable law. Meanwhile, Karen Reed herself took no position, because in court she was asked to state her position, and she took no position, meaning no opposition to the buffer zone, but also she was not for it. She doesn't care. Her lawyers don't care. At this point, they're focused on trial. That's why individual petitioners had to come together and hire Mark Randazza to do it. Because they... Yeah. I mean, that's why. All right, so it would require significant suspension of disbelief to say that banning demonstrations supporting Karen Read protects Karen Read. Right? Right? Like, how do pro-Karen supporters hurt her? Yet, here we are. Compounding this lack of evidence of any possible harm to Read is the single justice's order which uncritically accepted the Superior Court's unsupported claim that witness intimidation has been a prevalent issue in this case and erroneously stated that petitioners did not challenge these alleged factual findings. To the contrary, petitioners have repeatedly pointed out that there is no record evidence of any alleged witness intimidation or jury tampering. And the individuals who are being charged with witness intimidation are innocent of those charges and probably have a good leg to stand on that the government is railroading them because they're being charged with a statute that law enforcement is just choosing to use to weaponize the people against the people. So... let's read through this last part, the summary of the argument. So the Superior Court imposed a prior restraint zone that bans all demonstrations in an area 200 feet from the courthouse complex in Dedham, Massachusetts. This prior restraint zone provides that no individual may demonstrate in any manner, including carrying signs or placards, within 200 feet of the courthouse complex during trial of this case, unless otherwise ordered by the court. The prior restraint zone was created by a judge who lacked any power to do so, meaning Canoni did not have the power to do what she did, without any attempt to involve affected parties, the people who hired someone of the law of the court to represent them. The affected people hired someone to speak for them, and yet she chose not to listen. And in derogation of affected parties' rights. Even if the power existed, the court had no findings of fact and failed to narrowly tailor the prior restraint zone in order to properly abide the First Amendment. She basically just said, well, I'm going to take this on advisement, and she came back ruling with a 200 zone, and it was just ordered. And she didn't give us reasons as to why she chose to do what she did. She just restrained it from 500 to 200 feet. That's all she did. I don't know. She's so crooked, I think. Someone said that she's fair, but I don't know. Especially in this last hearing. Like, they can't even bring up, or we don't know yet, if they're going to be able to bring up the investigation into Michael Proctor, Trooper Proctor, and they cannot talk about the federal investigation, which is so stupid. Like, the federal letters and all that we went through before. They're not supposed to talk about that now. I mean, there were a lot of motions. I felt that Canoni ruled in favor of the Commonwealth in this last pre-trial hearing. I don't know. All right, so even if the power existed, the court made no findings of fact and failed to narrowly tailor the prior restraint in order to abide by the First Amendment. So there was nothing... There were other remedies that probably could have been done without violating people's First Amendment. and she didn't look into them, is what they're saying. Like, she needed to do that. There needed to be other options besides just, let's take away people's freedom of speech in this particular area, when could be people's homes and people's private businesses that are in those areas. And if you put up a free care and read sign, you're going to prison because you just broke the court order. That's contempt. Going to spend some time in county. It's ridiculous. You can't even like put up a free care and read sign in your own business or home if it's within the 200 feet. The order does not define courthouse complex, thus leaving the interpretation entirely up to the police. The police have so far interpreted it as 200 feet from the edge of the courthouse property in all directions. However, they have also interpreted it as prohibiting signs outside that zone if they criticize the zone itself. And they have people that have put up signs like buffer zone, no free speech. If you see in my thumbnail for this one, somebody put up a restricted area, no free speech beyond this point per the Commonwealth of MA. So, I mean, these signs are all over. People have put like no free speech beyond this point, and yeah, all kinds of different messages playing on the fact that their First Amendment is being violated. And there have been instances where the law enforcement have taken the signs off, like ripped them off of like the barrels and things that they've been putting them on, just to be I think just to be like a them versus us. I don't know. That's what I think they're trying to make it as. All right, so there are cases discussing legislative authority over such areas such as Cox versus Louisiana, but despite a good faith effort to find one, petitioners are unable to find a single case where a court purported to command contempt authority over demonstrators outside the courthouse grounds. However, there are analogous cases to consider. When courts seek to close their own courtrooms, third parties, usually media entities, are nearly always permitted to intervene. Think Delphi. She's closed the whole trial, and multiple members of the media have been writing letters and asking Judge Gull to allow cameras in the courtroom, and she keeps denying them all without a hearing. So when the courts seek to close their own courtrooms, third parties, usually media entities, are nearly always permitted to intervene because it is an effort to due process that a court can deprive citizens of their First Amendment rights without an opportunity to be heard. Non-parties may intervene where they would otherwise suffer a substantial injury to a direct and certain violation of their rights. Although petitioners have differing reasons for wishing to protest, most of them wish to protest near the courthouse for one unifying reason. Their protest relates to the Reed case, and there is no other location where their protests are relevant aside from that courthouse. Members of the media, members of the government, and members of the public who have an interest in the Reed case will all be present at the courthouse or watching the courthouse from afar from other content creators or from the media will be watching, and protesting elsewhere will not have the same effect. Petitioners have no interest in influencing the judgment of the jury or the truthful testimony of the witnesses. The Superior Court should have done the work of using a procedure that protects the First Amendment while using a scalpel to mitigate any concerns. There's totally lost my train of thought. But they're saying she should have been a lot more delicate in her in her orders when it comes to the First Amendment. She should have been very, very, very careful to protect the First Amendment and to come up with any other solution than to impede upon it. Instead, the Superior Court simply wiped the entire right to protest off the table. Doing so without narrow tailoring and without considering the input of the public was an error that the court must correct. And I'm not going to read through all the case law and everything through this. This is like I said, this is a long document, but some of their argument, I'm just going to go through the main points. So the court has no authority over public forums outside the courthouse. I think that's pretty explanatory. They should not and do not have the jurisdiction to the territory outside of their courthouse. In your courtroom, you're king. But outside your courthouse steps are public domain. So for them to do what they did is pretty outrageous. All right, so the next, I'm going to go to, let me go to my outline because I really don't need to read the argument. I just wanted to go through here. So this is the argument. These are the main arguments. So the court has no authority over public forums outside the courthouse. Like I said, they don't have the jurisdiction for outside the courthouse. In the buildings, they can dictate them however they want. In their courtroom specifically, they are king. What they say is word. It's like the word of God, whatever they say. And it must be done in their courtrooms. But outside, they shouldn't have any power. And there's case law that argues that. I'm not just coming up with that on my own. Also, the order is an unconstitutional prior restraint. So they argue in this that the statute itself that they are using for this buffer zone and for the witness, it's the same statute for the witness intimidation stuff. They just really love this particular statute to use it as a weapon against the people. So they're saying this statute itself is unconstitutional. You should not even be using it. And it's also not content-based. It is an unconstitutional content-based restriction. So it's not like it's a blanket, you're getting rid of all speech. No, it's just government speech. It's the speech you don't want to hear. It's the free Karen Read people. It's the Karen Read is factually innocent people. That's what the Commonwealth doesn't want to hear when they're coming into their courthouse. They want, I guess, a 200-foot, well, they wanted a 500-foot buffer zone, which I think is just extremely outrageous. Also, the single justice erred. So they're talking about when Cannoni, Judge Cannoni, the single justice, erred in making this decision. And all the reasons why. And then the right to intervene by the people. So there is a right by the people to intervene and to actually get a say. And she deprived them of that right. Let's see what the single justice erred says. Petitioners appreciate the prompt ruling by the single justice of the court due to the grave constitutional issues at stake. However, in denying the petitions, it was erroneous. First, the restriction is a prior restraint on free speech through footnote 8. Yeah, so basically when Judge Cannoni denied the petitioner's first, filing to stop them from doing this buffer zone, it was before she had even made her decision yet. and they were there ready to get, ready to speak on it, and she didn't give them that chance either. So she made a lot of errors. So I wonder what all their errors are saying here. Under that restriction, other individuals holding up their signs who were not acting in concert with the protesters would have been prohibited. Well, it's talking about whatever case. See, this is all case law. We don't want to read through this. But it does say this prior restraint zone is unprecedented and unnecessary, and I believe that. The restriction that has worked thus far, keeping protesters off the courthouse property, tried and true, but it's unnecessary. Yeah. The right to intervene, like I said, the people have a right to say how that buffer zone would affect them, and she never gave them the option. And that they say this alone is enough to vacate the order by denying the intervention. Poisoned the order under controlling Supreme Court precedent. That's interesting. So just the fact that she denied them in and of itself is reason enough to vacate the order. So let's go down to the conclusion now. Oh, I didn't mean to go that far. So, okay, let me center that because I don't like that. The Supreme Judicial Court should reverse the decision of the single justice and vacate the order establishing the prior restraint zone. It should use the opportunity to instruct the trial courts that citizens who will be affected by an order have a right to be heard prior to the entry of that order. Further, the establishment of a prior restraint zone is unnecessary when properly interpreted, leave ample room for the First Amendment, but address any concerns that could be imagined. If the court believes that prophylactic measures must be taken to ensure the integrity of the trial, it should instruct the Superior Court as to how to do that without stifling the First Amendment. And that is from Mark J. Randazza of the Randazza Legal Group. And so, what do you guys think about that? I mean, we're not done. We're going to read the amicus curiae, which I've already read before on my channel with another stream. I can't remember. We might have done it when the buffer zone first came out, because this part was submitted in the beginning, and this is like, sorry, I'm trying to get my blanket off me. I'm hot. I always have a blanket on me, but right now I'm warm. All right, so here is the document from the ACLU so the amicus curiae is like a document for the court to make a more educated decision. It's like a, hey, here, judge, let me give you some information about this case. And that's what that's what they did in this particular instance. They wanted to get back behind the petitioners. Not that they're backing the petitioners or anything, but they wanted to provide support as to what is buffer zone used for in other circumstances and how they've been implemented before. So, introduction. The American Civil Liberties Union of Massachusetts respectfully submits this memorandum as amicus curiae with regard to the district attorney's motion filed on or about March 25th, 2024, seeking 4 orders from this court. 1. Requiring prominent posting of GL 268-13A in and around the courthouse immediately before April 16th, 2024, I believe is what they meant, and during the pendency of the trial. So basically posting this order everywhere. That's what the Commonwealth wants, posting it all over. Also, prohibiting any individual from demonstrating in any manner, including carrying signs or poster or making statements about the defendant's law enforcement, the Norfolk District Attorney's Office, potential witnesses, or the evidence within 500 feet of the Norfolk Superior Court complex, which includes the parking area behind the Registry of Deeds building during the trial of this course. Number 3, prohibiting anywhere where prospective jurors gather or walk to the courtroom the wearing or carrying of papers, water bottles, tote bags, signs, buttons, pins, t-shirts, sweatshirts, hats, or any other attire or item that contains any image or writing that suggests a favorable or an unfavorable opinion of either party. Well, like we argued in the brief, the only people out there are doing favorable things for Karen Reed, or saying things in favor of her side. So you're really only banning one side of speech, one message. Number 4, prohibiting any individual in the courthouse from wearing any buttons, shirts, or insignia related to the defendant, the victim, or law enforcement. That right there is the one and only thing that I agree that the court can and does have control over. Number 4, prohibiting individuals in the courtroom from wearing anything with Free Karen Reed or a Justice for JJ pin, either way. Each of the 4 orders requested in the pending motion have an impact on free speech, expression, and assembly, and therefore require very close constitutional scrutiny by this court before any order might enter. The memorandum focuses primarily on the request for the whopping 500-foot buffer zone request, although the analysis below is applicable to each element of the request. We also have concerns about the request for posting of GL 268-13A at the courthouse, given it may be an overbroad and insufficiently tailored restriction speech in that it prohibits picketing near a building housing a court of the Commonwealth, which is arguably too vague. More appropriate than posting that statute might be the prominent posting of any buffer zone order that the court might enter to ensure that no one inadvertently violates it due to lack of notice. Of course, the statute shows that the legislature chose to restrict such activities undertaken with specific intent only when near a court, or as opposed to anywhere within a 500-foot zone on either side of the entire courthouse complex. Given it is clear, that's the next, that's the next footnote. I'll get to that one later. All right, so as explained more below, the court should proceed very carefully in ruling on the motion, particularly the buffer zone request, given the impact of free expression protected by both the First Amendment to the U.S. Constitution and Article 16 of the Declaration of Rights, which has been held to provide even greater protection for free expression than the First Amendment, including when criticism of the conduct of public officials is at issue. So this should be extremely protected speech. Free Karen Reed stuff is like not just protected, but like extra protected. Argument. For purposes of this amicus, it is assumed the request for the 500-foot buffer zone can be deemed content and viewpoint neutral, Footnote, given it is clearly motivated by a desire to suppress speech in favor of the defendant's perceived innocence, that assumption may be questionable. And this memorandum takes as a given that there is a strong government interest in preserving the administration of justice free from undue influence. There is, however, a serious question whether the requested orders are necessary or effective to serve such an interest, given the huge amount of press attention that has already been provided to this case, and the unlikelihood that many, if any, potential jurors or witnesses would not already have been exposed to. Where was that? Near the top. All right. But even assuming those predicates, the court still must conclude that the requested restrictions are narrowly tailored in that they do not burden substantially more speech than is necessary to further the government's legislative interests. In a case out of Massachusetts concerning 35-foot buffer zone near abortion clinics, damn it, I didn't mean to say that word, that were held to not meet the narrow tailoring requirement, the Supreme Court emphasized that by demanding a close fit between ends and means, the tailoring equipment prevents the government from too readily sacrificing speech for efficiency. In McCullen, the court also emphasized that the burden is on the government to show that it seriously undertook to address the problem with less intrusive tools readily available to it and considered different methods that other jurisdictions found effective. So she should have, instead of just coming out with a blanket order, she should have said, if I'm going to deny this, here's why I'm denying it, or here's some potentially other methods that I could have taken or undertook, but I couldn't because of whatever, this, that, and the other reason. So, I mean, she didn't even take the time to say that. So, anyways, indeed, in this case where a judicial injunction, not a statute, is at issue, the standard is even higher. As the Supreme Court has explained, injunctions carry greater risk of censorship and discriminatory application. And thus, when evaluating a content-neutral injunction, we think that our standard time, place, and manner analysis is not sufficiently rigorous. We must ask instead whether the challenged provisions of the injunction burden no more speech than necessary to serve a significant government interest. Of course, the Supreme Court has also recognized and discussed in McCullen that injunctions, if carefully drawn to apply only to individuals or groups because of their past actions in the context of the specific dispute between real parties, may be more consistent with free expression than more general laws because, given the equitable nature of injunctive relief, courts can tailor a remedy to ensure that it restricts no more speech than necessary. In short, injunctive relief focuses on the premise or precise individuals and the precise conduct causing a particular problem. So if you had a particular individual who is causing a particular problem, then you need to spell that out. But you can't just be overly broad and say no demonstrators. Period. You could say no demonstrators who, I don't know. I mean, you can't say no demonstrators who disagree with the government, but that would be like more narrowly tailored, you know? I mean that would all be all of them, but they can't say that. Sorry, I got allergies. It makes like my throat and my nose all itchy. Like, I don't know. I feel so congested lately. All right, so here the Commonwealth's motion makes no attempt to explain why less intrusive measures are not insufficient to protect its legitimate interests. Such alternatives may include enjoining only specific individuals from engaging in certain conduct where the government shows that they have in the past engaged in unlawful witness intimidation or interference with the administration of justice. So if you have a pattern of doing this, of intimidating witnesses as they're coming in, if this group has a problem doing that, then that's what you will ban in the zone, not just speech altogether. So any such violations would need to have been proven to have occurred with an intent to interfere with or obstruct the administration of justice, because intent is an important element in the protection of free speech as recognized by the plain language of the statute. Moreover, any generally applicable restrictions could be much more tailored, for instance, by only prohibiting demonstrators while expressing views about the case from approaching within a certain number of feet of someone entering, or in the courthouse restricting noise levels within 200 feet from the courthouse complex below a reasonable decibel level so that proceedings inside are not disrupted. So that's something you could do, like no bullhorns outside the courthouse steps. That's narrowly tailoring it because we don't want the noise. Like, that's a reason we don't want the disruption. The court conducting careful voir dire of each potential juror to ensure they can commit to judging the matter based only on the facts presented during trial and according to the court's instructions, and not as a result of media coverage or the influence of demonstrators, a much smaller buffer zone and or combination of the same. Conclusion: there are serious reasons to doubt that orders of the scope sought by the Norfolk District Attorney's Office can be justified consistent with free expression principles protected both by the First Amendment to the United States Constitution and Article 16 of the Massachusetts Declaration of Rights. Certainly, the district attorney seems not to have met the government's burden to show why narrower alternatives are not feasible, and unless and until that burden is met, the motion should be denied. And that is respectfully submitted on behalf of the ACLU of Massachusetts, Ruth A. Borquin. And that, my friends, is the end of part 1. Like I said, we're going to go over the Commonwealth's reply to all of this, and of course then the brief coming from the petitioner's reply to the my words are hard today. My brain sucks. Autoimmune diseases suck. All right, so I don't even know what I was saying anymore. So, yeah. Oh, we're going to read through the petitioner's response or reply. It's their second brief, or maybe more than that. I have no idea. And this is their response to the Supreme Court, because the Supreme Court wanted a expedited response. So hopefully we get an expedited response from them in return, because trial starts Monday, and it would be nice for maybe in the afternoon they get a decision and then they can all go back to the courthouse steps with no worries. I don't know. Once the jury trial has been selected, what does it matter now? It doesn't. It doesn't matter if the individuals come up to the courthouse steps. You can have the jurors come in the back door, which has been stated on numerous channels, my channel, multiple. Aiden Carney, the prisoners are escorted in and out the back door. So You can do that for, I mean, not to say that jurors are prisoners, but there is a back door and it's possible to get them in a different way without having to see all the protesters, if that's what they're so worried about. But really, they're just worried about how bad it looks for the Commonwealth. That's number one, ultimately, what they care about is how bad the Commonwealth looks. And I gotta say, if they should have dropped this case if they were really worried about how they looked, because they have doubled down so far into their corruption and their lies, and I can't wait. I'm here for it all to watch during trial. I cannot wait. And I will give you guys updates for sure on key witnesses and just, you know, the major things that happened that day. We'll do re-watches, but we're gonna do kind of like skim through. We're not gonna watch the whole day of trial, but we'll do a re-watch of certain portions of the day every day, and I'll give you my commentary and what I think. So that's gonna be the next, I don't know, 6 to 8 weeks for the rest of our lives here. It feels like a long time. We're in for a ride. Also, I'm very heavily invested in the Delphi case, which is happening soon in May. So I hope that these two cases aren't going at the same time, which I know they're going to be. And also, I really hope Judge Gull lets cameras into the courtroom, but that's neither here nor there. She won't, because she doesn't want the corruption shown. She doesn't want the world to know how corrupt they are. Anyways, I am out of here. Thank you guys so much for watching. Take care. Please be sure to leave me a note in the comments what you think about this trial, what you think about Karen Read, what you think about any of the players in this whole situation, in the whole story of the Karen Read, Turtleboy, Canton 9, anything. Let me know your thoughts below. Don't forget to hit the like button on your way out, and I will see you in the next one. Take care, guys. Bye. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know wrongfully convicted or accused of a crime, please write to crimeandpanel@gmail.com and tell real true crime encounters. For watching.